this afternoon. So before starting the guest lecture, I wish to Prof. Oxy to give a brief speech, maybe 1 or 2 or 3 minutes to open this guest lecture. Please, Mr. Oxy.
Oke, baik. Suara saya kedengaran, Pak Yan?
Kedengaran.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Warahmatullahi wabarakatuh.
Good afternoon. Greeting to all of us, the honorable, all the leaders, recent person, Mr. Banu, all the lecturer, all the student, and all the audience. Today, the Faculty of Law had an academic activity for the until time, namely an international guest lecture presented by a research person from India, namely Mr. Banu. How are you, Mr. Banu?
I'm very well, Prof. Thank you. How are
you? Mr. Banu will present material on comparative understanding, victim-centered law and practice in Indonesia and India. I hope that we can pay close attention to the material presented so that it can benefit for all of us in increasing even over our knowledge, especially about victim. Once again, let's follow this event until the end, and hopefully this event can run well and smoothly. Finally, I would like to thank for all those who have and support this event so that it can be held. I think that all from me. Thank you so much for your attention. I would like to apologize if there is a mistake written to moderator, Mr. Yoyon. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh. Terima kasih, Pak Yon.
Waalaikumsalam. Thank you very much for Oxy who has given a brief speech, represent the Dean of Law Faculty and also the head of Law Magister program. Mr. Banu, Prof. Oxy, and all students who have joined in this guest lecture. Before we start the guest lecture, I will to inform you about the brief curriculum vitae from our guest lecture, Prof. Banu Prakasnuna from RV University, India. Prof. Banu have the Bachelor of Art from CMR College, Bangalore University, and then he graduated from Master of Art from Psychology from Faculty of Art, also from CMR College, Bangalore University, and then he graduated PhD in Victimology from OP Jindal Global University, India. And then right now, Prof. Banu in charge as the Center of Victimology in the RV University, India. And then to Prof. Banu, we have about 1 hour to carry out the guest lecture. I think 30 minutes maybe for presentation from Mr. Banu, and then 30 minutes we have time for discussion. So I think 1 hour is enough because I know that after this guest lecture, you have another program. So I think in the when you presenting something, maybe once sometime maybe I wish to add something to you because maybe I have explaining to our student mixing in English and Indonesia. I think okay, yeah. Okay, okay, Prof. Anu, we can start the presentation maybe 30 minutes. I deliver to you to presenting the material from the thank you, Prof. Anu.
Thank you very much, Prof. Yoyo, and thank you very much, Professor Oxy, and everyone who is present here today. A very good afternoon and good evening. It's always a pleasure to be on a platform to deliver some talks and lectures to my Indonesian friends and students. It's always wonderful. So I've been interacting with Professor Yoyo and Professor Oxy for a good amount of time now, and I've been to universities of Pamulang last January. So I hope to return to Indonesia sometime soon again and be in Unpam again. Thank you so much for this opportunity. So please allow me to share the screen. I hope the slides are visible.
Already, ready.
Yeah. So what we'll be talking today is a comparative understanding of victim-centered laws and practices in India and Indonesia. So I will try and bring some kind of comparison between the legislative frameworks we have in India and the similar kind of legislative frameworks we have in Indonesia, how they are similar and how they are different. If there is anything that could be learned from each other countries. And I would also briefly emphasize on the victim support framework that India and Indonesia adopts. So when I'm talking about the victims and victim-centric laws and victim assistance in this lecture, I'm referring to women and child victims who are victims of violence. So the legislative framework related to women and child victims and the legislative frameworks related to women and child victims primarily in Indonesian context and Indian context is what I'll be talking about today. And I'll try and draw as many comparisons as possible from the realistic point of view. So the overview of today's presentation, like I said, we will be talking about procedural justice. What is procedural justice? How is it different from any other kind of justice we know? And why procedural justice is important in the context of victims, victimology, and victim justice. What is the purpose of procedural justice? And it's important. I'll speak about it. Victim-centric legislative framework, both in India and Indonesia, and interventions. What kind of victim support initiatives we have in India and Indonesia. So we will be looking at these aspects in this lecture today. Like I said, I'll be talking about procedural justice for victims. What is procedural justice? So procedural justice is not a beginning and an end. It puts emphasis on the process. So when a victim files a complaint till the victim gets delivered justice, what happens in between filing a complaint to the delivery of justice? How the police speak to the victim, how the court proceedings happen, how the judge talks to the victim, how the lawyer speaks to the victim, what are the formalities that the victim has to go through, what are the kind of support that the victim gets in the court, in the law enforcement officers, in the public media, what kind of support victim gets, what is the process and procedure adopted in order to ensure justice for the victim. It is called procedure justice. So basically, we are not talking about voice, not just the voice for the victim, but also recognition for the voice, valuing victim and making sure that victim's voice is heard, adequately understood and adequately supported in the process of seeking justice for the victim. So the importance of validation and acknowledgement. If I have suffered a crime, I have undergone traumatic hurt and pain and losses that I've incurred. So now somebody wants to understand this pain. I want other people to know that I was hurt. I want the acknowledgement. I want the validation that I have gone through some difficult situations in life. So being treated with dignity and respect is more important to victims than results, such as particularly sentencing or punishment. So victims, there is several research which clearly indicates that victims are not concerned about the quantum of punishment awarded to the offenders. They really are not bothered whether an offender is sent to 10 years jail, 10 years imprisonment, or 15 years imprisonment. They do not care. What matters to them most is how are they treated by the police, by the court, by the doctors, by the victim support personnel, by the neighborhood, by the community, by the family, by the relatives. How they are treated becomes more important than what they get out of this justice process. So procedural rights can be ensured by ensuring victims' rights. Victims' rights can equally equated to human rights. So any victim right is not a far deviation from a human right. So victim rights are human rights. So to ensure procedural justice, it is very important that we ensure victim rights are upheld and victim rights are made implementable and enforceable. There is a difference between providing rights and making them enforceable. So any law can be made in the country to give right to the victim. But what is equally more important is to have mechanisms to ensure that these victim rights are implementable. And if there is a violation of victim rights, then there are consequences for violating these victim rights. Such mechanisms, to ensure such mechanisms is tough a task. Victim-centric legislative framework in India. These are some of the laws that I want to bring to your notice. These are laws relevant to women and child victims in the Indian context. So we have a law like the Indecent Representation of Women Prohibition Act. So indecent representation of women is prohibited. Sexual Harassment of Women at Workplace Act of 2013. Protection of Women from Domestic Violence Act. Intimate Partner Violence, Domestic Violence Act. Dowry Prohibition Act. I don't know if you're familiar with the term dowry. Dowry is basically the money or the property or something that is given to the would-be husband, in-laws, in order to get married. So the girl's family gives some cash and gold and jewelry and property to the boy's family in order to get married. So this kind of practice is called dowry, and it is prohibited by the Indian law. Prohibition of Child Marriage Act. So I know that India and Indonesia differ in these laws, some of these laws, especially the Child Marriage Act. Protection of Children from Sexual Offences Act. In 2012, the government of India has drafted a legislative framework to protect children against sexual offences, and this act is called POCSO Act of 2012. In the POCSO Act, I want to draw your attention to this POCSO Act for a time being now. So under POCSO Act, the Amendment Bill of 2019, the penetrative sexual assault, according to this bill, the punishment has been increased from 7 years to 10 years. And if the child's age is below 16, then the punishment can go up to 20 years. And if the penetrative sexual assault is of aggravation, if it is an aggravated penetrative sexual assault, the minimum punishment that could be awarded is from 10 to 20 years. Can somebody mute?
Tolong dimut itu siapa?
So the minimum punishment is from 10 to 20 years, and the maximum punishment could go up to death penalty if it is an aggravated penetrative sexual act. In POCSO, it is a child-friendly, victim-friendly legislation. Recording statement of the child by police, by court, enough care must be taken to ensure that the child statement recording is done in a very safe environment. Child not to see cannot come in contact with accused. Every effort must be made to ensure that child does not have to face the accused. Police officer not to be in uniform. According to the POCSO, if a police officer has to investigate, speak to the child, then the police officer cannot be in the uniform. Appointment of guardian. If need be, the child should be given a right to appoint a guardian, support person, facilitators and translators. If the child speaks a different language other than the local language, then the translators must be provided. In-camera proceedings, the child must be allowed to do video recordings instead of attending the court to provide the statement. And enough care must also be taken in the court. Questions by the public prosecutor, defense counsel to be given to the judge. So the lawyers cannot ask the child question directly in the court. They have to submit their questions to the judge, and the judge has the right to ask the child. Judge can alter the kind of questions that are asked by the public prosecutor and the defense lawyer, ensure that sensitivity is maintained all times. Judge alone to put questions to the child, frequent breaks if needed. If the child requires frequent breaks, then that must be granted. Child-friendly atmosphere must be provided. There should not be media that is allowed in the court if there is a child case hearing happening. So anything that is threatening and feels unsafe for the child must be kept away from the environment. Not called frequently, so there should not be multiple hearing dates. The child must be put at convenience. No aggressive questioning or character assassination is allowed in case of a child victim. Non-disclosure of identity must be followed. The media cannot report the name or publish the photographs of the child victims. Compensation to victim. If it is a POCSO Act victim, then certainly there is compensation provided within the law in the country. But with the POCSO Act, I would like to also bring to your attention the challenges that we faced with the implementation of POCSO Act. There is poor conviction and increased dependency despite POCSO. So with POCSO, the number of cases have increased, though most of the crimes that were once not criminally liable now have started to become liable and are punishable. And the judiciary is overburdened because of the increasing number of cases of POCSO. Overuse of the law. So law has been overutilized, meaning if both a child and an adult, if they are in a consensual relationship, as per the POCSO, if the girl is a minor below 18 years of age, then this boy could be punished even if the relation is consensual, according to the POCSO Act. Such kind of misuse and misappropriation of the law has been in several of the cases noticed, and consensual sexual acts of children, elopement, running away from home and getting married in a different town and city. So these cases are also quite common in the country. Teenage pregnancy. Now, how do you handle teenage pregnancy within POCSO? If it is a consensual relation, a teenage is pregnant, then the person responsible for making this girl pregnant must be put behind the bars. That is what the law says. But we also must understand that these are consenting underage children who are getting into consensual romantic relationships, and those cases must be handled with different kind of legal measures. Marital rape within POCSO. This is a quite challenging concept, which India is still not able to break its head around. Victim-centric legislative framework in Indonesia. So we have spoken about the Indian context and the legislative framework. Now we look at the Indonesian legislative framework. Indonesia has promulgated Act number 13 of 2006 concerning witness and victim protection. I'm sure most of you are familiar with LPSK Act and its amendment, Act number 31 of 2014, to give protection for the victim. So it's called Witness Victim Protection Act in English. In Indonesian, it is called LPSK. I'm sure most of you are very much familiar with it. The demand for LPSK law, it came from the community groups. So there is a societal pressure which put on the government to enact such kind of law in the country. LPSK provided protection to the victim, but limited to victims of grave violation of human rights. So the offense has to be very, very serious for it to be qualified for the benefits under LPSK. Like, for example, human rights violation of grave nature, terrorism, trafficking, torture, sexual crime, and serious assault in the form of compensation, restitution, and victim support. The support is provided according to LPSK. So LPSK is so concerning the rights of victims of the crime, according to LPSK, you can get an individual, family, and property protections and freedom from any threat in providing testimony. So it is also a law that ensures protection to the victims, not just the victims, but also the witnesses. So while the witness or the victim providing testimony, the protection becomes paramount, and this law guarantees, according to the law, protection is guaranteed. To participate in the process of choosing and determining kinds of protection and security support. So the victims can be made part of the security decisions taken by the law enforcement officials. They can be consulted and their suggestions can be taken into consideration while making protection arrangements for the victim. To participate in the process of choosing and determining kinds of protection and security support, to provide witness testimony without any pressure, to get a translator if need be. We were looking at POCSO and other cases where translation, right to have a translator was mentioned in the Indian legislative framework as well. Here in Indonesian framework also, you see a translator, if required, must be provided. Protection from jeopardizing questions, to be informed regarding the case progress. So information rights are very, very crucial when it comes to victim rights. To be informed of the court decision, to be informed if the convicted is released. So the information rights are also very much safeguarded through LPSK law in Indonesia. And when it comes to victim rights within Asia, Indonesia has certainly made quite a good progress in compared to any other countries within Asia in this context. Japan, of course, has advanced victim rights, and so Indonesian victim rights are also quite progressive and very modern. LPSK can also ensure victim identity confidentiality, and victims can also get a new identity. To get a temporary home, they can get a new home if required. To get transportation fee compensated, if they are arranging a vehicle to go to the court, to the police, or to the hospital, then that kind of transportation fee can be reimbursed. To get a free lawyer, legal aid is guaranteed through LPSK. To get living costs during the protection period, if they are put under protection provision, then their loss of livelihood, they cannot go to their work, they cannot go for the jobs. So if there is a loss of livelihood, then it will be compensated. To be accompanied by another person if required. Victim advocate, for example, to have a side person who can be there with the victim and provide the moral support. So, however, this act is not yet fully in line with the declaration. We know UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. According to that, victim participation rights are not clearly listed or not clearly emphasized in LPSK. Same is the case with the India too. The victim participatory rights are pretty much undermined as per the existing legislative framework. And so another law which is very, very significant in the context of women and child protection in Indonesian context is TPKS Law, Tindak Pidana Kekerasan Seksual, if I pronounce it right. So the TPKS Law. On April 12, 2022, Indonesia's parliament, very recently, the Indonesian parliament has passed the draft law on the elimination of sexual violence. So this is certainly a long overdue, right? This is a step, forward-looking step to ensure the rights of victims of sexual violence in Indonesia. TPKS law sets out 9 different kinds of sexual abuse. These sexual abusive behavior were not recognized earlier. Most of them were not recognized earlier. With TPKS law, these are recognized now. Forced contraception, for example, forced sterilization, forced marriage, sexual torture, sexual exploitation, sexual slavery, sexual abuse through electronic means, which is a recent phenomenon. In the last decade, we have seen increased cases of online sexual abuse, technology facilitated sexual violence. So we've been seeing the spike in this number of cases. So some of the highlights of TPKS law: the law dictates procedural rights for handling sexual violence cases, protection rights that guarantee that law enforcement authorities do not degrade or blame victims, and recovery rights. 3 important rights that are ensured by TPKS law: procedural rights, protection rights, and recovery rights. The emphasis is on restitution and compensation. The law also indicates that a victim trust fund must be established. So in order to support compensation claims for the victim, there must be a separate fund allocated for the benefit of this kind of provision. TPKS law is a legal umbrella that covers the entire dimension of sexual violence in Indonesia. It recognizes the sexual abuse both within and outside of marriage, recognizes online sexual abuse. This is for the first time, the recognition of sexual violence within the context of marriage was given some due attention in the Indonesian legislation. So definitely this is a step forward to these kinds of victims. And the law also stipulates that victims of sexual violence receive restitution and be provided with legal, medical, and counseling support. So we will talk about this integrated victim support centers. I've come to know that Indonesia also has these centers set up. And I'm quite happy that we have these victim support centers dedicated to provide integrated services to victims now. It allows the submission of one evidence instead of two, along with victim statement. So earlier requirement of two witnesses is now cut down to one witness, along with the victim statement. Psychologist report is submissible now. If the psychologist makes some clinical observation and provides that, then that becomes part of evidence. Police must file a case, no scope for refusal. Even in India, we have a concept called zero FIR. FIR is first information report to the police. It is similar to police cannot refuse filing a case if it is being filed by a child or a woman victim. No financial settlements in sexual crimes, right? Same in Indian context also, the court does not allow you to make financial settlements. So it is the government versus the accused, the case that will be taken up by the court. So, so this is the very briefly the legislative frameworks and the comparison between India and Indonesia. Now we will quickly look at the victim support services that are available both in India and Indonesia. I'll try and draw some comparisons to both the countries. Okay, and the need for victim support in India is huge. You will see every year millions of victims are in need of victim support. It could be women victims, it could be child victims, victims of violence of different kinds of nature, right? And there are several reports that are published which indicates that the need for victim support is huge in the country. And India in 2012 has following the gang rape incident, which horrified the entire country and globally. Following that, the decision to set up integrated one-stop centers in the country was made. And the first center was launched in 2015. So we now have over 700 one-stop centers in the country. And we have about 20,000 victim support personnel working in these centers. About 500,000 women and children victims have already been benefited through these one-stop centers. These one-stop centers provide emergency rescue services, women helpline 181 facility, psychological counseling, medical assistance, legal assistance, police assistance, shelter, video conferencing facility. In case of the victim cannot go to the court, the video conferencing facility is also provided. So these are some of the services provided by the one-stop centers. These are some of the pictures of some of the one-stop centers that I visited. So most of them are not in a good condition. The infrastructure is very, very poor in these one-stop centers. But I've also seen a very well-maintained, good infrastructure one-stop centers as well. These are victim support centers in one of the cities in India. And these are also one-stop centers, but in very poor condition. So this is a well-built, very modernly equipped one-stop center. You see an underutilization of resources. So these are air coolers, air conditioners that are lying unused. And this is the premises of the one-stop center. 181, this is the National Integrated Women Helpline number. So anybody, a woman who is in need of rescue or emergency services can dial 181 and the support can be provided to these women victims. So the idea is to link these women helpline to one-stop centers, but it has not been successful so far. And so India has also set up a separate victim compensation fund with the support from the Nirbhaya Fund. So about 6 billion Indian rupees were segregated, set aside for women and safety related projects in the country. And after 10 years of setting up a fund, we still have 30% unutilized funds in this budget. And the mismanagement of funds also led to stalling of release of funds. So there is a lot of misappropriation and misutilization of this fund, which was meant for the safety and security of women, but it was underutilized, and there were several complications in terms of releasing these funds because there was a lot of corruption. And the practical support in Indian context for victims is we have panic buttons. Now you see the mobile phones have emergency SOS button. You can simply press that button and hold for 5 seconds. Your emergency contacts will be alerted. Such kind of provisions are being made in the public transport systems and private cab facilities. Right, panic buttons have been installed. And technical support has been provided. Women police stations. This is also a step forward in the Indian context. We have all women police stations. The entire police station have equipped staff with women. Pink public transport dedicated for women alone. No male person can take that public transport assigned to the women. Dedicated seating and coaches in public transport, anti-trolling response. These are some of the examples of public transport that I'm talking, which is dedicated only to women. So if you see a bus or an auto rickshaw in the country in pink color, which means it is dedicated only for women and girls. A male person cannot enter this public transport. Women police stations, we have over 700 women police stations, but the challenge is that the women police force is only about 10% in the country. 90% police force is men, so it is logically impossible to set up more women police stations in the country because of shortage of manpower, resulted in a 23% increase in reporting of crimes against women and children. So definitely the crime rate reporting has certainly increased with women police stations. But again, the judiciary has failed. Similarly, in POCSO cases, like in POCSO cases, even here, the judiciary yet again has failed in terms of meeting up to the crime reporting and resolution of these crimes. And so this is about India. Now we can look at the context of Indonesia and the victim support in Indonesia. Right. I spoke about the one-stop centers. Now I see that Indonesia has also started setting up integrated one-stop victim support centers in different parts of the country. Women's Empowerment and Child Protection Minister, Ms. Bintang Puspayoga, she has called for the creation of a one-stop integrated service to ensure women and children victims of violence and to have access to assistance. The one-stop service is follow-up to Law Number 12 of 2022 on crimes of sexual violence in the Indonesian legislature. This law provides 6 different services: request handling, victim outreach, meaning rescue services, case management, temporary housing. We also have similar kind of facilities in our one-stop centers, mediation and victim assistance. Victims will directly be assisted by the social officer for their rehabilitation, for psychological support and mediation or rehabilitative services. Social officer is responsible, and the health officer is responsible for medical services. In addition, legal assistance and investigation will be done. All of these services will be provided under one roof. So the victim has to simply make a visit to one place, and all these guaranteed support services are available in this center. So this is the concept behind one-stop centers. Victims need not make several visits to different facilities in order to get the support. Victim can go to one place, and all the professionals who are in concern of providing victim services will be available in that center to provide the required support services for the victims. So this is the launch of, I think, the first integrated victim support center in Indonesia in Semarang City. So Central Java, Semarang City, there is first integrated victim support center established in 2022. And so my research was on integrated victim support centers like Saki one-stop centers. And these are my findings from my research. When I looked at the implementation of one-stop centers in the Indian context, these are some of the drawbacks that I have noticed. I thought Indonesia, since it is recently has setting up the one-stop centers, there is so much that Indonesia can learn and avoid making mistakes, the mistakes that we did. For example, training and recruitment must be given enough emphasis. The training of staff must be adequately done, and the recruitment must be done carefully. True integration of services. With the model with which the one-stop centers are set up is to provide integrated support services. So if the integration fails, meaning there should be a good cooperation between different stakeholders. There should be free exchange of communication between stakeholders, and cooperation must be ensured between different stakeholders. Infrastructure. India has a lot of disadvantage when it comes to one-stop centers. There is poor infrastructure and adequate funding. So this project must be funded adequately. Clear roles and responsibilities of people who are working there must be laid out very, very clearly. Awareness and outreach. People must know what these one-stop centers are. What are the facilities provided at these one-stop centers? How can one access support from these one-stop centers? So this kind of information must be made publicly visible, and enough promotion must be done in order to ensure the awareness levels are high. Salaries and benefits for staff. The adequate salaries must be paid to the staff. Otherwise, you will see very soon the people will start leaving these places. Transportation and grievance redressal must also be ensured. So victim compensation, when you look at, both countries have victim compensation. In India also, there is victim compensation guaranteed by Section 357 of Code of Criminal Procedure Code. The quantum of compensation would be decided by District Legal Services Authority. The difference between the Indian victim compensation law and Indonesian victim compensation law is that in India, even if the offender is released or acquitted, right, it led to an acquittal. If the victim needs to be rehabilitated, then a decision regarding victim compensation can be made. Victim compensation can be provided in cases of offender being released, offender being acquitted, or if offender is not traced. If the police cannot find the offender, even in that cases, victims can be compensated as per the Indian victim compensation law. Whereas when I looked at Indonesian victim compensation law, if the offender is not guilty, then the victim is not entitled to get the compensation. Victim will not get the compensation according to Indonesian victim compensation law. Correct me, please, if I am wrong. This is what I understood from the literature. In case that the culprit does not have enough property, right? If the offender is not in the paying range, if he cannot pay, then the victim cannot be compensated. The only recourse in that is the court will increase the punishment in exchange to not paying the compensation, right? So there is an increase of 1 year imprisonment in case if the offender accused failed to pay the victim. So there is an increase of 1 year imprisonment. But how is the victim being benefited in this context? So victim needs to get the fair share of money, the monetary compensation, in order to reconstruct the life, okay? If the victim is not being provided the monetary compensation and the offender is being simply put to jail for 1 more year, this is not doing good to either. Okay, so Indonesia has to reinvent itself in terms of being more victim friendly in providing victim compensation. It must also establish an integrated agency for victim assistance. Okay, there has to be a overseeing agency. I know that the ministry overlooks, but it has to be a separate department which looks after victim support in the Indonesian context, and sufficient budget must be allocated. All of this would require a lot of money. We are talking about hugely populated countries. Indonesia and India are hugely populated. We are looking at so many people who are in need of this kind of support. So it would require a lot of money, and sufficient budget must be allocated. Some of these challenges that I've noticed in Indonesian context is that, about TPKS law, this is a very recent law, and there has to be derivative regulations. So you have a legal framework now, but what is important now is how do you make this come into enactment? How can this law be enacted in the Indian context, Indonesian context? What is required to do that? So such kind of derivative regulations must be given enough attention now. Lack of integrated victim support services. Yes, now this would be resolved with your integrated one-stop centers. Lack of public awareness about the TPKS law or the integrated victim support system or the victim compensation schemes. There is huge unawareness in the common public. Political will to keep the victim in the center. Victim-centric laws and victim-centric policies would require a lot of political will in order to be made real. Okay, and yes, police and judiciary will have a lot of reluctance in terms of changing. Police are not ready to change. Police are not ready to do their job differently to accommodate victims. Similarly, the judiciary. The judges also do not want to change their mindset. For them, it is seeing whether the offender is guilty or not. The entire process is built around to prove or disprove the guilt. Now, accommodating victim in that space could be quite challenging, and this is something that both Indonesia and India must foresee in terms of making victim-related policies and bringing out changes in terms of favoring victims. And some of the common challenges that I've identified between India and Indonesia is that no legal consequences for procedural mistakes in handling victims of violent crimes. If there is a violation of victim right, if the victim is mishandled, if the victim has been secondarily victimized, there are no consequences for somebody who is causing that. Meaning, if I cause more hurt to the victim, then I'm not facing any consequence, right? So violation of victim rights are not punishable. Rehabilitation of custodial crimes is also a common phenomenon in both India and Indonesia. So what is the kind of rehabilitation for custodial crime victims? The rights of victims of cybercrime. Okay, this is a quite recent phenomena that we are seeing now. And very soon we'll have 50% of traditional crimes moving to virtual space. So you'll see more and more crimes happening in the cyberspace now. So both the countries must be prepared in terms of facing these kind of challenges. Urgency to adopt victim impact statement in the criminal justice systems. Both India and Indonesia must have provisions for recording and making the victim impact statements as part of crucial judgment processes. No universal victim compensation scheme. So if you look at India, different states have different compensation schemes adopted. So there is no one victim compensation scheme in India. Similarly, Indonesia also must evolve in terms of strengthening victim compensation schemes and providing much and much more support. Poor integration of victim support. You have OneStop Centres, we have OneStop Centres, but what is more important is to ensure that they are well integrated. Special attention to rights of victims with disabilities. This is a separate section, victims with disabilities, minorities, different sexual orientation. These are different kinds of populations, and this set of population would require a little more sensitivities than usual. Restorative justice-based justice models. Okay, so I think both countries now need to look at and explore restorative justice-based models instead of the age-old traditional punitive methods of just punishing the offenders. So we'll have to evolve and see what is more beneficial both for the victim as well as the offender, and try and adapt those modern and less damaging criminal justice models. So basically, I would want to end my lecture by saying that the real test of the criminal justice system is not how well we punish our offenders, but how well we treat our victims. So this is the essence of procedural justice. This is said by Professor Chokkalingam. He is the father of Indian victimology. And so according to this, so the real test is to ensure that victims are treated well in the criminal justice, not that offenders are punished well. So that's all from me. Terima kasih. Thank you so much. And thank you for giving me this opportunity. And I'd like to take, if there are any questions, I'd like to answer them. Thank you so much.
Thank you very much, Prof. Banu. A wonderful presentation. Yeah. We still have about 15 minutes we provide for the discussion, but before we start the discussion, I will to summarize your presentation. Okay, Prof. Banu?
Yes, Prof.
Okay. So I will summarize a little in bahasa Indonesia. Okay, Prof. Banu? Okay?
Yes, Prof.
Okay. Para mahasiswa, para dosen, alhamdulillah kita sudah mendengarkan satu presentasi dari Profesor Banu Prakasnuna ya, berkaitan dengan bagaimana pentingnya untuk kita memperhatikan korban ya. Nah, saya untuk merangkum dari dari semua presentasi sebetulnya sudah dijawab ya, sudah di close oleh Prof. Banu berkaitan dengan the real test of the criminal justice system is not how well we punish our offender, ya, but how we treat our victim. Itu sudah sebetulnya itu sudah kesimpulannya. Artinya bahwa sebetulnya untuk melihat bagaimana sistem peradilan pidana yang nyata sebetulnya bukan bagaimana kita menghukum pelaku ya, bukan hanya pelaku offender ya, tetapi kita juga bagaimana memperhatikan dan memberikan perawatan kepada korban gitu. Itu sebetulnya yang dirangkum dari semua. Tapi bagaimanapun para Bapak Ibu semua bahwa kita tahu bahwa India dengan Indonesia berbeda karena Indonesia adalah sejarahnya adalah kolonialisme dari civil law, sementara India adalah sejarahnya adalah kolonialisme dari council law ya. Memang exploring berkaitan dengan realismenya sudah berkembang jauh ya. Tapi kalau kita lihat dari penjelasan di awal bahwa bagaimana parlemen India mempersiapkan regulation about bagaimana perhatian kepada korban ya. Dan bagaimana pada abad ke-20 juga Indonesia sudah mulai fokus bagaimana negara konsen kepada korban, sehingga dibentuk juga di Indonesia ada LPSK ya. Itu ada bagian dari bagaimana perubahan itu. Bagaimana negara di India lebih maju tadi, bagaimana negara India memberikan bahkan kompensasi pun negara menyiapkan itu. Nah di kita Prof. Banu, I think in Indonesia about compensation, I think we do not apply it in Indonesia because so many things trouble about budget, about bureaucracy, something like that. I think different than India ya. I think di sini Bapak Ibu ini adalah satu paradigma bahwa, tetapi Bapak Ibu kalau kita melihat daripada hukum pidana yang baru atau the new crime law itu sudah masuk di dalamnya bagaimana victim korban juga attended diperhatikan oleh negara. Tapi kan itu nanti berlakunya beberapa tahun lagi ya. Jadi Bapak Ibu, rangkuman dari kami bahwa bagaimana hukum pidana modern itu bisa bisa ada perubahan ya. Perubahan tidak hanya memutus memberikan efek jera kepada pelaku, memberikan hukuman kepada pelaku, tetapi bagaimana korban juga harus menjadi perhatian dari negara. Ini barangkali rangkuman dari presentasi yang disampaikan oleh Prof. Banu. Dan karena waktu ada 10 menit, ya saya ingin kepada para audien, ya kepada para mahasiswa, dosen, silakan untuk memberikan pertanyaan. Mungkin satu langsung, dan boleh dalam bahasa Indonesia. Nanti kita akan coba saya translate ke dalam bahasa Inggris ya. Prof. Banu, the question maybe from bahasa Indonesia, I will try to translate to English ya. Silakan dimulai siapa? Langsung saja namanya. Dimut. Ada? Ada pertanyaan, Bapak Ibu? Apa sudah paham semua ini? Pak Dedi silakan. Ada yang bertanya Pak Dedi? On the screen nih. Pak Edi dari Serang, ini dari Unsur Utama Serang. Mau bertanya? Oke, Pak Edi. Please, one question. Tidak ada suara Pak Edi, bisa di-mute suaranya Pak Edi. Pak Edi, suaranya Pak Edi. Halo? Halo? Bapak Ibu, suara saya kedengar Bapak Ibu?
Terdengar, Pak.
Dengar.
Terdengar.
Berarti ini ada masalah di Serang nih. Ya, ini ada masalah di Serang Pak Edi ini dari Unsut nih. Dari Serang nih. Iya, Unsut. Prof Anu?
Yes, Prof.
I think your presentation is very well. There is no some audience to ask some about the material. I think.
Yep, I see a question in the chat here.
Okay.
I think Safwan from class of Faculty of Law. Safwan was asked. She was asked about what about boys who are sexually harassed, and what kind of legal provisions are there. So both the laws that I've discussed, I'm not sure about TPKS law in Indonesia, whether it has the provisions for men victims, but definitely the legislations that I've discussed in Indian context does not include men victims of sexual violence or sexual harassment. So both legislative frameworks must evolve to also incorporate men who are also victims of sexual violence and sexual harassment. This is definitely a need of the hour. We see increasing number of sexual abuses happening towards boys and men, especially younger boys. We've seen this happening across the world as a global phenomenon. And both in India and Indonesia also, there could be increasing number of cases of boys who are sexually abused and harassed. So yes, POCSO, certainly the child protection law that we have in Indian context definitely addresses to children who are boys and who are minors. But for adult victims of sexual abuse, the law must be strengthened in the Indian context. And similarly, I think Indonesian context also must pay enough attention to the victims who are men and victims who are boys, and they must be safeguarded from protection against the sexual offenses. Thank you for that question.
Baik, bisa saya rangkumkan Bapak Ibu bahwa sebetulnya di dalam bagaimana kita perhatian kepada victim itu memang di dalam kekerasan seksual khususnya memang sepertinya itu selalu menjadi korban itu kan wanita. Sepertinya di dalam korban yang dimaksud di dalam victimologi adalah semua korban ya. Hanya di kita biasanya dalam kekerasan seks adalah wanita dan biasanya kalaupun laki-laki itu termasuk anak-anak yang di bawah umur ya. Tapi pada dasarnya bahwa victim itu adalah semua pihak yang terlibat atau terjadi berkenaan dengan kekerasan di dalam seksual. Ada lagi Prof. Banu?
Yes, Prof.
Oke. Siapa nih? Halo, siapa nih? Satu orang? Siapa?
Prof. Good afternoon, Prof. Irfan, Prof.
Oh, Pak Irfan, silakan Pak Irfan.
Ya.
Monggo.
Good afternoon, Prof. Banu, Prof. Opti, Prof.
Ya.
Yoyon.
2 menit, silakan.
Yeah. Question to ask regarding the Prof. opinion on how to become a qualified legal advisor. Thank you.
Oh baik, Pak Irfan, in India or in Indonesia?
Indonesia.
Oh, Indonesia.
Yes.
Advisor for lawyer or advisor for what?
Yes. Terkait pendapat Prof. Banu, bagaimana menjadi penasihat hukum yang berkualitas, Prof?
Oh, saya. Oke, Prof. Banu, this is the question from the Pak Irfan, the student from law magister. He said that to become the professional lawyer, yeah, how way to becoming a lawyer, not just
professional
lawyer, yeah, just national level, maybe regional, international level. Okay, 5 minutes, Prof. Banu.
Okay, I think there are some bar examinations you'll have to clear. If you are looking at practicing at the international level, so then you have to be qualified international law practitioner. There are certain licensing examinations you'll have to clear for you to become a practitioner at the international level. So definitely you'll have to clear your bar examinations within the country. You have to first become a qualified lawyer in the country of your origin and education. Then based on that, you can apply for international law practicing licensures. And there could be several bar clearance examinations which you could attend to practice law. For example, if you have to practice in India, you will have to clear the Indian bar examination in order to practice in the Indian scenario. Similarly, if I have to practice in Indonesia, I'll have to study Indonesian law and clear the qualified examinations there. With the international context also, you'll have to understand the international law, different laws within different nations. And so, for example, International Criminal Court, ICC, if you have to practice in ICC, then there must be a separate examination which you have to clear in order to be qualified to practice at International Criminal Court. So different requirements based on where you want to practice and what kind of practice is it.
Oke,
Thank you, Prof.
Oke, Pak Irfan begini, memang untuk menjadikan sebagai ahli hukum yang personal dalam level nasional dan internasional tentunya ada beberapa prasyarat yang harus ditingkatkan. Mungkin itu tentunya tiap negara memiliki perbedaan apa namanya beberapa prasyarat sehingga mungkin sebagai seorang lawyer harus mengembangkan itu sehingga masuk ke negara mana termasuk ke India. Prof. Anu.
Yes, Prof.
Is any regulation, for example, some lawyer from Indonesia who has ID license from the court, and then automatically can be practice a lawyer in India, for example, there is regulation, Prof. Anu.
I don't think, Prof, but I think through embassy, within embassy, you can be appointed as lawyers.
Yeah. Okay.
In the general court systems, you'll have to clear Indian law, Indian law examinations. But for embassy, you can certainly work because it is by Indonesian law. And for embassy, in embassy, you can certainly be appointed as lawyers representing Indonesia.
I think the important thing maybe we can cooperating between lawyer in Indonesia and lawyer in India.
Yes.
Yeah, to practice about the case. Yeah.
Yes.
Okay, Prof. Anu, I think the time almost finished because after this lecture you will also have another program. So thank you very much for your time who has given us the knowledge and your experience. And then I hope we can see you again in another chance to give us another material. So, and then thank you very much to all students, to all lecture in Jakarta, in Serang, and in another place. So I hope this occasion we can explore for the time. And then before we closing the guest lecture, I hope to Mr. Oxy to give the brief speech to close the program. Let's, Prof. Oxy. Prof. Oxy, are you still on the screen, or are you already asleep? Because Prof. Oxy is preparing, this is the certificate from Mr. Bano already.
Thank you.
Oh, yeah. Okay. So because Prof. Oxy has so many activity in Serang City, Prof. Bano to preparing the accreditation of the law science in Serang. So maybe we don't have any time to close this program, so I will directly close the program. Yeah.
Sure.
Thank you, Prof. Banu, about your time, and then I will express our greeting to you, to your family, especially for your mother. We pray so that your mother healed well, ya, Prof. Banu. Ya.
Thank you.
Oke, Bapak Ibu semua, acara kita sudah selesai. Mudah-mudahan kita bisa bertemu lagi, dan kepada bapak-bapak ibu yang mungkin di kelas semester 1 kemarin saya. Nanti ketua kelas tinggal mengirimkan nama-namanya ke saya yang hadir, nanti insya Allah akan disiapkan sertifikatnya, dan mungkin di luar magister hukum bisa dengan Pak Dekan, Pak Kaprodi di Fakultas Hukum ya. Thank you very much, Bro Banu. See you later. Ya, keep health.
Thank you.
Ya, keep health.
Bye.
Okay, thank you very much. Yeah, I will permit. Thank you very much.
Thank you, Prof. Take care.
Oke, thank you. Bye-bye.
Bye. Baik, Bapak Ibu, Mr. Banu sudah closing, dan kami dari penyelenggara khususnya dari Fakultas Hukum dan Magister Hukum mengucapkan terima kasih kepada Bapak Ibu semua, karena kami dengan India ada kerjasama sehingga harus ada implementasi. Ini adalah satu implementasi dari kerjasama selama ini. Terima kasih, selamat beristirahat. Mohon maaf telah mengganggu 1 jam, dan mudah-mudahan nanti awal September jangan lupa perkuliahan. Dan jangan lupa registrasi. Ya, saya izin pamit ya.
Pak.
Oke.
Terima kasih, Pak. Ya, ya. Assalamualaikum.
Salam.
Waalaikumsalam warahmatullahi wabarakatuh.